Mr. Lott, I'm sorry you've been detained. As you probably have noticed, there have been some technical problems with our laptops. So if we need to adjust the time, we will do so.
Thank you very much, my Lord. I hope that the equipment works. I was beginning to feel like a sort of antiquarian working with hard-copied files, and was thinking that I should go electronic, but perhaps I'm safer with paper. My Lords, my Lady, I was making the submission before lunch that the concept of cause of action is to be understood as certainly containing the notion of a right to go to the court to ask for relief. And I'll just pause there and just consider briefly that concept of relief. I fully accept that as a matter of the English language, it is possible to regard a declaration in the terms that you have asked the court to make as relief. It can be of value. It is sought because it is of value, in that it establishes the law and prevents the other parties to the proceedings from contradicting the declaration in future litigation. So in that sense, a declaration could be said to be relief. But my submission that in the context of a discussion about the doctrine of merger, the term relief is to be understood in a narrower sense. Relief means a coercive order by the court which requires the opposing party to pay something, or, in some cases, to do something, or in other cases, obviously, to refrain from doing something.
So it orders for payments and different forms of injunction.
Exactly so, my Lord. Yes, that's the submission. And if that is right, and if the analysis that I have advanced as to the meaning of cause of action is right, then it follows that the court should consider closely and sceptically my learned friend's argument that in this case the claimant is seeking in these proceedings to obtain a judgment on a cause of action for the second time. The innocuous word on in that formulation is ambiguous. It might mean a judgment which in some way is concerned with a cause of action. Or, this obviously is my preferred analysis, it might mean, in the usual sense, a judgment on the cause of action, i.e., a judgment which grants relief, in my narrow sense, on the cause of action which has been asserted before the court. The declaration made in this case by Mr. Griffiths was a declaration, certainly it was a declaration which was concerned with the cause of action in debt, which my client had, and we say still has, against the defendant. So it was concerned with that cause of action. But on the analysis that I am advancing, it was not in the relevant sense a judgment on that cause of action, because a judgment on that cause of action would have been a judgment for the claimant in the relevant sum of money.
On your case, what's required is a right to an order, which then is transmuted by the court into a new court-ordered right, which replaces the previous cause of what was the cause of action.
Indeed, my lord, and that is the, as my lord will anticipate, that I submit is the only way one can make sense of all the case law which speaks of the lesser or the lower or the inferior interest or right being merging in and being replaced by and extinguished by the superior right or interest, which is what the coercive judgment of the court represents.
I think one has to be a little bit careful with what you said about injunctive relief, because one could imagine a situation similar to this, where you got a declaration that the shares were forfeit and an order preventing the defendant from purporting to sell them, or an order that he hand over the certificates, if certificates actually still exist in any handover form.
Yes.
I think it would be whether you would want to say in that because you got that sort of ancillary relief, that then was a judgment which would bar a future claim for the money, I think might be a bit difficult.
That would be in my submission. Excuse me. In my submission, that would go too far, and that would operate too severely. This case is obviously not directly concerned with the obtaining of an injunction, and difficult questions might arise in other cases on other facts, where the claimant goes to court, gets a declaration, gets an injunction which is in some way ancillary to the declaration, but does not seek any monetary award. The argument that, not this case obviously, but the argument that could be advanced by somebody, as it were, on my side of the court, would be that if any right, in those circumstances, if any right has merged in the judgment, it is the right to obtain an injunction. It is not what could be said to be a separate right to monetary relief. And that set of facts is not far away, not very far away, from the facts that were before the court in Serrao, where the plaintiff obtained an order for delivery up of the shares and then sought money later, and in what could be regarded as quite a severe decision by the Court of Appeal, which had been much more benign in the Brunsden, the cab driver case. The Court of Appeal said no, action 2 barred. Query, was that right? And if it was right, query, what was the ratio for that decision? And of course, the second broadly similar case is the Farrar and Leon Green case. The judgment, Lord Justice Sales, as he was, where the claimant obtained an order for possession and then came back in the second action and sought an order for payment of mean profits and was permitted to do so. And it was in that case that Lord Justice Sales expressly held that the true ratio of the difficult Serrao case was that it was an early Henderson and Henderson case, and that the Court of Appeal had essentially held that it was abusive for the plaintiff in Serrao not to make both claims, bring both claims at the same time. So I fear I've fully answered the point made by my lady, but I'm effectively saying cases involving the obtaining of injunctions raise what may be subtly different and fact-sensitive questions.
So on your case, you could commence an action on certain facts, claim only limited relief. That limited relief would be transmuted into an order of the court, and you could come back and claim other relief at a subsequent stage, subject to Henderson against Henderson.
You may be able to do so, but you would certainly be at risk of meeting a Henderson and Henderson argument, and if objection to the second action.
But that's the only thing that prevents you from doing that.
Yes, that's my submission. I'll say a little bit about Henderson and Henderson and the subsequent case law in a moment, but I certainly submit that the Henderson principle, as developed in the recent case law, has rather sharper teeth than my learned friend was inclined to accept in the course of his submissions. Can I then approach my further submissions in the following way? Can I say something about declarations and the development of the jurisdiction to grant declarations in an attempt to identify the fundamental differences between court's general jurisdiction to make coercive orders and its declaratory jurisdiction? Can I then, intend, if I may, to make a submission about merger, and I'm going to found that submission on what I hope will be a persuasive defence of the analysis of Mr. Spencer Bauer in his seminal work, which has remained the leading textbook for almost exactly 100 years. I'm going to attempt to persuade the court that Mr. Spencer Bauer presciently foresaw the point that has been taken in this case and dealt with it. And we shall see how he expressed himself. I'm then going to shortly develop my submission that Mr. Spencer Bauer was right in his analysis of the relevant point. And then I shall deal very shortly with 3 or 4 points of detail on cases cited by my learned friend, make some closing remarks, and I should be completing my submissions, I hope, in good time. The first matter to look at, therefore, is the declaratory jurisdiction, and we have in the bundle quite a long extract from the book on the declaratory judgment by Lord Wolfe and Jeremy Wolfe, which is known as Zamir and Wolfe. This is the second edition, published in 2011. Fourth edition, thank you. Fourth edition, published in 2011, which we understand is the up-to-date version of the book. We find it at 1472. And the book, the first chapter, begins with these words: a declaratory judgment is a formal statement by a court pronouncing upon the existence or non-existence of a legal state of affairs. It is to be contrasted with an executory, in other words, coercive judgment, which can be enforced by the courts. And the text then elaborates on that fundamental distinction. Then, if I needn't take up time with that, then if I can ask the court to move to 1474. At the top of the page, we see this: the declaratory judgment is an old established institution, said to be as old as judicial history, and the footnotes refer to Roman law, but the text then goes on as follows: yet, though old, it was of minor importance until fairly recent times, It began to flourish only in the last century, in England not before 1850, and after that only slowly developed. And that is, as the Court of Appeal in this case noted, that's an important part of the context against which the Court will consider the development of the case law, because when judges were making decisions about the scope of the doctrine of merger in the 19th century, it is fair, in my submission, it is fair to infer that they simply would not have had in mind the possibility of anyone arguing that a mere declaration would cause the doctrine of merger to be engaged. Then if one turns on to page 1476, the authors continue their discussion of declaratory proceedings and the differences between the distinctions between declaratory proceedings and other types of litigation. And at 110, towards the top of the page, one sees this. Another notable feature of declaratory proceedings is that they are the ideal means of resolving disputes amicably, with less danger of generating the antagonism which can be caused by the adversarial nature of litigation in a common law jurisdiction. And Professor Sunderland is then cited, quoted. Professor Sunderland referred to the said personal animosities, and he went on, to sue is to fight, and fights make endless feuds. Parties hesitate to resort to the courts because they shrink from a state of war with their neighbours or business associates. But if the courts could operate as diplomatic instead of belligerent agencies, less hesitation would be felt over recourse to them, and less strain would be put upon the friendly relations of the parties. To ask the court merely to say whether you have certain contract rights as against the defendant is a very different thing from demanding damages or an injunction against him. And that is...
I wonder how much time Professor Sunderland had actually spent sitting in a court watching.
It certainly doesn't strike me as being less antagonistic, necessarily.
The distinction between diplomacy and war in the context of a court battle may be quite subtle.
It could be said that seeking declarations is conducting war by other means in most cases. As I was reading that out, I did think that I might meet some scepticism with the bench as to that analysis. However, defending the professor's position...
Sorry for interrupting. And if I could just bring you back so I can fully understand the case that's being made. You say you can bring on facts relief for any type of relief you like. And as soon as that's transmuted into an order of the court, then that's the end of that relief. The point against you is that that leads to all sorts of difficulties about finding out what is a type of relief. So, for instance, in the Indian Grace, there is a claim for damages. That's the end of the claim for damages. Okay? I think you accept that proposition, is that right?
Yes, I do.
Right. And then what do you say in reply to, well, this causes a whole lot of confusion, because people then will want to analyse what the type of relief is, and there'll be new arguments about that.
In practice, there will not be.
Yeah.
In practice, these cases are almost always, not always, but almost always about money. And the case, and I'm not seeking, as the court knows, I'm not seeking to ask to persuade this court to abolish the doctrine of merger, which will be a very hazardous operation because it has been part of the law for hundreds and hundreds of years. The paradigm case is where a claimant goes to court and gets a judgment, gets a monetary award, gets a judgment in debt or in damages because he has a certain grievance which he makes good before the court. Merger even if I'm right in this appeal, and I win this appeal, merger will continue to operate in such a case, and in some circumstances it will operate quite harshly. The traps exist. For instance, where you have a loss that is partly insured, and the insurer has its subrogated claim, and the insured wants to claim for uninsured losses. That can create difficulties when one party or the other goes to court first. Too bad. Merger has its limited role to play in the law, and it may operate in such cases. You have cases like Indian Grace, where by some mischance, a very modest sum was obtained in the Indian courts with very significant consequences. So be it. That's the paradigm case. There may be tricky, fact-sensitive cases involving the obtaining of injunctions, but we're not involved with that type of factual situation here. But difficult to see problems arising very frequently in that area. But those hard cases, setting those hard cases to one side, the ones that I have spoken of, if merger, the doctrine of merger, is properly kept within limits, properly confined to the area that it is intended to operate, it's not going to cause practical problems in many cases. And the spectre of defendants being subject to unfair double vexation, which was referred to many times by my learned friend in his submissions this morning, as the court knows, my answer to that is, well, yes, that does exist, and that can be and is already addressed by the courts using the Henderson and Henderson abuse doctrine, which is flexible.
I mean, there aren't that many merger cases, are there?
No, I mean, my learned friend and I have been, learned juniors have been pouring through centuries worth of case law. On my side of the court, of course, I've been looking for the case that is missing.
Modern cases, not.
Yeah, indeed. Yeah. But no, there aren't that many cases in the reports in which merger has played a part, which is probably just as well.
On your argument, you don't have to establish that merger doesn't apply to declaratory relief, because that was, you say, we didn't claim damages.
Indeed.
That's the end of it.
Indeed. So, obviously, my primary submission is that the Court of Appeal was, and Mr. Spencer, echoing Mr. Spencer Bauer, the Court of Appeal was right when it said, in terms, judgments or orders which are merely declarations cannot found a plea of merger or former recovery. That's my primary case. The Court of Appeal was precisely right to hold that, and I'll seek to make that good. If this court was not persuaded of that proposition, then the next question, the second question, would be, did this declaration cause the monetary claim to be extinguished by reason of the doctrine of merger? And my answer to that is no. This declaration did not do so, and Mr. Justice Burse, as he was, put the point very succinctly when he said it was very strange. It would be very strange for a declaration that said there was a debt cause that debt to disappear. So I make that second submission, but the oral submissions I make this afternoon are firmly directed towards making good the primary proposition.
And the primary proposition is that the doctrine of merger simply does not apply to declaratory relief.
Exactly, yes. Exactly. So I've taken the court to the possibly high-minded views of Professor Sunderland about the merits of declaratory litigation. Just in defence of what is said there certainly are cases where the declaratory jurisdiction can be used in a constructive and cooperative way between parties who, for instance, are keen to sort out what is meant by a complex trust deed or a pension scheme or something of that sort. And if the appellant's case herein were well founded, then this court may well see that practical difficulties might well then arise, because parties go to court, go to a chancery judge to get a declaratory ruling as to the operation of a complex pension scheme. If the declaration that the court, or the set of declarations that the court is being invited to make, is capable of engaging the doctrine of merger, then the parties are going to have to be looking over their shoulders all the time just to work out whether it could be said that the declarations are, quotes on, close quotes, a cause of action. Because if they are, then they might have to complicate the proceedings and possibly impair relations between the parties by including a claim for coercive relief or risk losing it. And that would be undesirable. Continuing the consideration of Zamir and Wolf, could I ask the court to go, please, to turn, please, to 1477. At the foot of the page on 1477, we see this. We see it being said that when the declaratory judgment made its presence felt in English law in the middle of the 19th century, it did so in connection with proceedings involving the construction of wills and trust deeds. For a few decades, it was regarded with suspicion and kept within narrow limits. This attitude, however, gradually changed. By the beginning of the 20th century, it had already won full recognition and appreciation. So, what my learned friend said about the relatively recent development of the declaratory jurisdiction in this country this morning was precisely correct, unsurprisingly. There are two further passages I'd go to in this textbook, please. If we turn to 1495, here, further on in the book, at 4237, halfway down the page, we find a section headed Monetary Remedies and Declarations. And the text reads as follows: where a person is entitled to a monetary remedy, for example, damages in contract or tort, or judgment for a sum of money or for the repayment of a loan, he will rarely be satisfied with a mere declaratory judgment. If, however, he seeks a declaration only, there will generally be no reason for the court to require him to claim a money judgment instead of or in addition to the milder remedy. What one can take from that is that the authors of this leading book on declarations certainly did not have in mind the possibility that the obtaining of a declaration might cause the doctrine of merger to be engaged. And indeed, there is no reference, so far as we can see, anywhere in this book to the possibility of merger arising where a mere declaration is sought. Then, if on the same theme, if we turn, please, to 1502, we find there a section headed Where Concurrent Remedies Are Claimed. Declaratory relief is often claimed and granted in combination with executory relief. And I simply wish to draw attention to footnote 28. One looks down to footnote 28 at the bottom of the page. We see this, e.g. with an injunction and damages, case is cited, and then with an order for specific performance, another case is cited, and so on. And then the footnote says this: it may be an abuse to litigate matters which should have been raised in earlier proceedings, see there's a reference to either the White Book or a book called Civil Procedure, I'm not sure which. That is obviously a reference to the Henderson abuse-based jurisdiction. I fully accept, indeed it's part of my case, that Henderson does apply, is capable of applying to actions for declarations. If a claimant, putting a little bit of flesh on that, if a claimant comes to court appearing to be a virtuous litigant and confines his case to an application for a declaration, but is sitting on, covertly, is sitting on an intention in due course to use the declaration to obtain some sort of monetary relief, but finds it expedient to conceal that from the court and from his opponent, then that claimant might well find that a second action for monetary relief will be treated as an abuse by the court, using the Henderson jurisdiction as elaborated by the Aldi case, which, as the court knows, in very clear terms, establishes as a matter of mandatory proper procedure that a party who is contemplating further litigation in the future connected to the subject matter of the instant litigation is under a duty to inform the court and the other parties of his intention.
Quite hard to see how that could be so. Perhaps there could be extreme cases, but the declaration by itself, because it doesn't require the other party to do anything or not to do anything, would have thought there's always the risk that once you've established the right, the other party might ignore or violate it, in which case you'd need some coercive order.
Indeed, Lord. In the usual run of cases, indeed that would be the case. And here, as the court knows, the courts below have held, and this is not the subject of the appeal, the courts have held that it was reasonably clear to all concerned that the claimant was intending to keep open the possibility of pursuing the debt against the defendant.
Is that conclusive? I mean, suppose you do make it clear, but the defendant still says, I don't want to have to go through this twice. If you want a claim for damages, then bring a claim for damages. I mean, the defendant, however much it's told that there may follow a claim for damages, there's not really anything they can do to avoid the vexation of the second proceedings, if you're right.
I think, my lady, that there may be scope for the defendant to take steps in that respect. If the defendant, for one reason or another, wants to obtain certainty as to the relevant liability, the rationale underlying the Aldi case and the Aldi principle is that the party who intends to keep alive the prospect of getting some money in the future must engage with the court, and that will obviously involve engaging with the opposing party as well. And the court will then manage the situation. So if the defendant wants to bring everything into focus and achieve certainty then and there, it would be open to the defendant to say to the court, no, I do not think it's acceptable for there to be further expensive litigation at some point in the future. I think we should grasp the nettle now. Again, the court may be sceptical as to whether that will happen in practice in most cases, because most defendants are not too keen on grasping the nettle of immediate liability. But it could be done, and the thrust of the Aldi case and the subsequent case law is engage with the court, tell the court what you're intending to do, then the parties can work out how to proceed most economically and effectively.
Your primary submission is that declaratory judgments are just not subject to the doctrine of merger.
Yes.
But that, to my mind, at present, can't stand on its own because of Section 34. And which refers to cause of action and judgment, and so that you're always driven back to actually understand what the doctrine of merger is, and you say the doctrine of merger is people are perfectly entitled to choose their own relief, and as soon as they get relief from the court, that's the relief that's transmuted into the order of the court.
Yes.
And that's nothing more than that.
Yes.
Yeah.
Indeed.
But can the declaratory relief point stand on its own?
I submit that it can, and it does, my Lord, yes. And I'm going to try to make good that submission by reference to a very careful analysis in Mr. Spencer Bauer's book, which I hope will indicate why the declaratory declarations and merger don't mix point is well-founded. Just to complete my submission on declarations, can I certainly identify a case which, recent case, which is significant in that respect. We can pick it up at, in the bundle at 813. That's the case starts at 798. It's a case called London Steamship Owners Mutual Insurance and the Kingdom of Spain, and the state of France was also a party to the litigation. The head note begins at 798. I'll simply identify this case and the relevant passages for the court, keeping one eye on the clock. This was and probably still is a very large, very substantial piece of litigation arising out of the pollution damage caused to the French and Spanish coasts by a ship breaking in two and sending a lot of oil into the water. And the relevant insurer brought arbitration proceedings in London, which were, among other things, designed to obtain a declaration that the two injured parties, France and Spain, were bound to arbitrate the claim in London. And the insurer obtained that declaration, which then underlay the claim which the insurer made in the English courts against Spain and also, I think, against France. And if the court would look, please, at page 813, the relevant claim that was being made by the insurer against Spain and France is described as, towards the foot of the page, as the award claim. And the claim, that claim sought damages or compensation for breach of the defendant's obligation, Spain's obligation, to honour the relevant arbitration award, which was a declaration that declared that the matter should be pursued in an arbitration in London. That was the award claim. The court held that claim had no prospect of success, and it did so on the basis of an extended consideration of the effect of a declaratory award. And that passage, and I'm going to do no more really than to identify that passage in the interest of moving on to more central points. That passage begins at page 840. 840. Foot of the page, the effect of a declaratory award. The judgment then goes on to set out a lengthy passage from Zamir and Wolfe, and then on page 841, the court will see that the decision which is under appeal herein was then considered by the Court of Appeal in this case at some length. Not going to take up time, unless invited to do so, I'm not going to take up time with the detailed nature of the judgment. I simply want to identify it. One can read on to, I can take the court on, please, to page 844. Paragraph 117. There the court noted that a declaratory award is capable of being, quotes, enforced, close quotes, for the purpose of the 1996 Act, in that a judgment can be entered in terms of the award for certain purposes. But then the court ends that paragraph by saying this, but there is nothing in that case, the case referred to detract from what is said above as to the nature and effect of a declaratory judgment or award. And that then leads one on to the court's conclusions. And again, I shall simply identify the relevant passage. It's at page 846. Foot of the page, under the heading Conclusions, paragraph 122, drawing these threads together. There is, in our judgment, no support in any of the authorities to which we have been referred for the proposition that a purely declaratory award, such as exists in this case, is capable of creating any obligation, breach of which gives rise to a cause of action for damages or equitable compensation. And the analysis continues over the page through to paragraph 126 and refers again to the present case, the Court of Appeal's decision in the present case at paragraph 124, where it is said that, as Zavarco underlines, a declaratory award or judgment does not create new obligations or extinguish existing obligations, but merely declares what those existing obligations are. So there, I need to move on, but there we see the Court of Appeal referring with implicit approval to the Court of Appeal's decision in this case and deploying the Court of Appeal's reasoning in this case to identify and to emphasise the important distinctions between a declaratory award and coercive judgments. So that is all that I wish to say in oral submissions about the nature of the declaratory jurisdiction. May I now make a submission as to the nature of the doctrine of merger and as to why it is that Mr. Spencer Bauer was right to say in his seminal work in 1924 and in every further edition of that work, was right to say that declarations and merger do not mix, as I put it, by way of shorthand. The starting point at page 410 is to remind oneself of Mr. Spencer Bauer's involvement in the law. At 1410. At 1410, we have the frontispiece of what was then the first edition, the new book, The Doctrine of Res Judicata. And Mr. Spencer Bauer, whose name will be well known to all members of the court, well known to all practitioners, was able to claim that he was the author of leading textbooks in a number of different fields. He was obviously a jurist who was steeped in the case law of the 19th century and earlier periods. The textbook is technically an authority to which I can refer, even applying the old rule about authors being it being necessary for the author, sadly, to be dead, because Mr. Spencer Bauer has moved on. But that apart, it is what he has to say in this book deserves, I respectfully submit, deserves very close attention. We can imagine him sitting in his rooms in the Inner Temple, surrounded by the English reports and a lot of 19th century case law, which he obviously knows backwards, and composing this work, which remains 100 years later the leading work on res judicata. And it's notable that, with respect, and I understand the pressures of time, it's notable that my learned friend in his submissions has not advanced any sustained criticism of Mr. Spencer Bauer's analysis of the point. So, what is that analysis? Well, it's a very careful analysis. Can I take the court to it, going in the first place to page 1413. The heading of this, the title of this section of the book is Res Judicata as a Bar to a Subsequent Recovery. And at 294, the author says this, Res Judicata has a twofold operation. Not only does it estop the parties from afterwards controverting any question or issue thereby decided, but it also bars the party who has obtained relief thereby from subsequently receiving the same relief against the same party. And where the author refers to a twofold operation, he is there drawing the distinction, which my learned friend referred to quite rightly on quite a few occasions in the course of his submissions, between what he called the type 1 situation and the type 2 situation. The type 1 situation involves a true estoppel where the earlier decision or judgment of the court is not capable of being contradicted by the parties to that decision in subsequent litigation. So that is a rule against contradiction. And that is obviously not what we are concerned with in this case. That's got nothing to do with the doctrine of merger. The type 2 sort of case, which is our case, is the merger case. And in the type 2 situation, the relevant rule is not a rule against contradiction, it's a rule against reassertion. It operates where a party is successful in action number 1, and the doctrine of merger has the effect, where it applies, that party cannot reassert the cause or right of action that was asserted in action number 1 in action number 2. So it's a rule against reassertion. The text then goes on at 295 to discuss that rule, and I can read down, I think, six lines down. A bar or plea of this nature, known as former recovery in civil cases, putting criminal cases to one side, is essentially distinguishable from the estoppel per rem judicatum, which has hitherto been the subject of inquiry in 2 respects. In the first place, the latter prohibits contradiction, the former repetition and reassertion, the point I've just made. Then it goes on. Secondly, that which must not be controverted in cases of estoppel is the proposition of law or finding of fact expressly declared by or necessarily involved in the res judicata, the yussive or prohibitive part of which is of no importance whatever, except so far as it presupposes a determination of such question of law or issue of fact. Then this. Whereas in cases of former recovery, the situation is reversed. The thing which is not allowed to be sued for a second time, being the relief and remedy granted by the yussive or prohibitive part of the res judicata, and the judicial determination, express or implied, of any question of law or issue of fact being, as such, absolutely irrelevant. So, there, in a very carefully analysed piece of text, the author is going straight to the point, which is at the centre of the primary submission that I make to this court. The author is identifying the fact that the doctrine of merger is a rule against reassertion, and is saying in terms that what a party who is to whom the doctrine of merger applies is not permitted to do is to reassert a claim to the relief and remedy granted by the, in old language, the yussive and or prohibitive part of the judgment that the court has made. And if that is correct, and I respectfully submit that it is, then that's an answer to this appeal. So the question for this court, the first question in relation to my primary submission, is obviously, is Mr. Spencer-Bauer correct when he says that?
So they can't do that even if they wanted to bring forward completely different arguments from the issues that had been determined in the court below. That's the difference.
Indeed, my lady. The claim is gone. The right to the relevant sort of relief or remedy has been placed before the court. The relevant facts, the facts deemed by the litigant to be relevant, have been placed before the court. Successfully, the judgment has been entered in favour of the claimant. That is it. And that is what merger is designed to deal with.
So merger does apply to declaratory relief, insofar as if you get one judgment for declaratory relief, you can't come back again and get the same judgment again.
Well, you
wouldn't want to, of course.
You wouldn't want to.
Yes.
I mean, the wider principles of res judicata and estoppel certainly apply to declaratory judgments, of course, because the whole purpose of a declaratory judgment is to bind the parties to that which has been decided. But merger, on my submission, is that merger, correctly understood, the doctrine of merger does not apply to a declaration.
Which is not a yussive or prohibitive judgment.
It does not command and it does not prohibit.
Yes, yussive is to command.
Yeah.
I'm sorry, what?
Yussive is to command.
I think so, yes.
Yes. So, in terms, it wouldn't apply to a declaration of a fact or the existence of a legal right.
Exactly. The declaration tells the parties, may fix the parties with a finding as to the facts or a determination as to the law, but it does not command and it does not prohibit. The parties have to, a party has to come back to court to obtain a coercive order if that party wishes to invoke the court's powers and the powers of the state to enforce the relevant right. That's the fundamental distinction which Mr. Spencer-Bauer is focusing on here. The text it goes on at considerable length to consider the relevant principles, and in the time available, can I draw attention to one or two particularly helpful or relevant passages? On page 1414, at paragraph 297, the author considers the underlying theory, the underlying theoretical justification of the doctrine of former recovery, which is the term that he uses interchangeably for merger. And the theoretical basis and justification has been put, it is said, in three different ways. The court will see what is then said. In the first place, from the point of view of public policy, it has always been insisted that the general interest of the community in a speedy and final termination of disputes between litigants demands the imposition and rigid observance of such a rule. With reference to Lord Cook, one reads over to the top of the next page, 1415. The court will see what is said there. And the court will see that Mr. Spencer-Bauer is here has in mind the principle that it's in the public interest that there should be an end to litigation. Very familiar principle. And there's a reference to contentiousness and to speculative attorneys and so forth, which says what it says. Then, at 298, the second theoretical justification for the doctrine is that which has been emphasised by my learned friend, namely the principle against, one might call it the principle against double vexation, a very familiar Latin tag that has been referred to already on a number of occasions. So that's the second theoretical justification, which is connected to is based upon the interests of the individual litigant and the provision of proper protection to a defendant against being harassed unjustly. Now, if one just pauses there for a moment to take stock, the desirable objectives that underlie the first two theoretical justifications that are referred to there are, I submit, in modern conditions, addressed satisfactorily by the modern doctrine of abuse, Henderson and so forth. As the court well knows, that the modern jurisdiction, abuse jurisdiction, requires the court to make a broad, merits-based judgment as to whether the second action, one way or another, amounts to unjust, oppressive harassment of the defendant or some party to the litigation. And by exercising that jurisdiction, the court can promote the two desirable objectives that are identified here, while at the same time, on the facts of the particular case, avoid the sort of injustice that has been apparent in some of the cases that the court has been looking at today. The third theoretical justification for the doctrine of merger is very important and tells one why it is that the mergers and declarations don't mix. 299, the text goes on. Thus far, the theoretical groundwork of the rule is the same as that of the doctrine of estoppel per rem judicatum. There is, however, a third theory on which the bar of former recovery has been rested, but which in no way supports the rules of estoppel. This theory, fully developed in Cook's time, though not perhaps meeting with universal or unqualified acceptance in the earliest periods of our jurisprudence, is of the following nature. Any cause of action which results in a judgment of an English judicial tribunal whereby relief is granted to the plaintiff or other actor in the proceedings is in contemplation of law merged in the judgment as soon as pronounced and thereby loses its individual vitality and disappears as an independent entity. The court will see how the discussion continues. And then at the foot of the page, one sees this. Strongly though it savours of scholastic metaphysics, this view is perhaps, after all, the only one of the three which completely accounts for and justifies certain features in the doctrine of former recovery which differentiate it from the doctrine of estoppel. For instance, on this theory alone, and not on the ground of either public convenience or private justice, can it be deemed right or reasonable to declare, as the law has declared, that a foreign judgment is no bar to a subsequent recovery. And then the text goes on. I'm not sure I fully understand the last two lines of that passage. So the third theoretical...
I think it must be referring to joint, isn't it? The joint liability
I think so, my Lord, yes.
It's referring to the two common law rules which may not...
Both of which have been abolished.
Which was abolished in 1934 or thereabouts, yes. Yes. In fact, both have been abolished. Yeah. Indeed, which may tell one something about the merits of the doctrine itself. But in this passage, Mr. Spencer-Bauer is quite correctly identifying the fundamental conceptual justification for and underpinning of the doctrine of merger.
Well, it's more a theory than a justification. I mean, what he's saying is that the particular doctrine of merger applies in the context of this theory.
Indeed.
And that's enough for you.
Indeed.
Yeah,
My Lord is...
a declaration of fact, how can that extinguish the facts? Or a declaration of a legal right, how does that extinguish that which has been declared?
Indeed. My Lord is gratefully adopt that. My Lord is quite right. It's not so much a justification; it's a theory. It's conceptualising the doctrine of merger. And the core point, fundamental point, is this. The court has the point. But the fundamental point is this: when a cause of action, correctly construed, merges in a judgment, there is conceptually, if you like, a trade. There is a swap or a substitution. The successful claimant asserts the cause of action before the court, proves the necessary facts, and then in exchange for doing all of that and, per the doctrine of merger, giving up the cause of action, surrendering the cause of action, receives in return the superior interest which is represented by the coercive judgment which the litigant can then enforce using the coercive powers of the state. And that exchange or trade is right at the centre of this antique doctrine. If that is right, I have the solid authority of Mr. Spencer Bauer's analysis there in my favour. If that is right, then that is an end of this appeal. Because if that is the correct way to conceive of merger, then, as my Lord has perhaps suggested, then one cannot see how a mere declaration, which does not confer any immediate rights at all, can bring into existence a merger. So that is, and it was very prescient of Mr. Spencer Bauer to foresee this argument, because it was difficult to see that it would have been in focus in 1924. But perhaps, this may be the way the common law develops, perhaps somewhere, and we haven't been able to find it, lurking in the 19th century case law, there was some judicial observation which caused Mr. Spencer Bauer to think about these things. But he did think about them, and he analysed the matter in that way. And that led to his very clearly expressed conclusion, the last thing I want to go to in the text.
Just to interrupt you for a moment.
Yes.
Although it's not a policy justification, at least if merger is looked at in its narrowest way, it would be a strange thing if, having pursued a right to a court order, when you get that order, you still had that right.
It would. It would. I mean, the doctrine is capable of causing problems, but
of course it gets difficult when you want to say, well, how big an area does the court order shut you off from coming back a second time?
Indeed.
But if it's exactly the same, nobody could really complain that there was anything wrong with that principle.
No, and the doctrine can operate harshly in the Republic of India type situation, the Indian grace situation, where for one reason or another you recover a very modest sum in action number one, and then work out that you should have been claiming 2 million plus rather than 6,000. Then it operates severely, but that I accept on behalf of the respondent here, that is one of those things. That is the way the doctrine works.
Just going back to the London Steamship and Spain Company case, in there the award claims, which I think are the ones that you highlighted,
yes,
were something separate from other claims seeking to enforce the arbitration clause in the contract and claiming damages for breach of the arbitration clause. they were separately trying to claim damages for breach of the arbitration award, which had been a declaratory award.
Yes.
But as I understand it, nobody suggested that because they had got a declaration as to the effect of the arbitration clause, that meant that they could no longer claim damages for breach of the arbitration clause, even though they had no cause of action for breach of the award. Is that
that is exactly right, my lady. There was no question of a merger coming to existence because of the arbitration award, which made a declaration about that
the arbitration clause was binding.
Exactly.
Yeah.
No party, as I read the judgment, no party argued that gave rise to a merger. The reason I went to that to that decision is because of there's quite a long discussion of the differences between declarations and coercive judgments in the Court of Appeal, which refers, I think impliedly approvingly, to the Court of Appeal's decision in this case. That was my purpose in going to that.
If you obtained a declaration, but then on second thoughts thought that wasn't quite the sort of declaration that we wanted, and you came back again for a second time, what would the position then?
If you obtained a declaration in certain terms and then had second thoughts and decided to go back to court and say, that wasn't it, that wasn't really what I meant after all, I'd like
a little bit extra here.
Like a little bit extra.
Yes.
Might depend on the facts, one might say at the outset, but if one was simply asking for a little bit extra, then that would be permissible. If you were asking for the court to contradict its earlier ruling,
that's a different.
That wouldn't be.
I mean, that's a stopple as opposed to merger. So,
indeed. So exactly, Lord. But if you're asking for a little bit extra, subject to the court's power to control its own procedures, there is no objection. There would be no objection in principle to that. The court has a discretion as to whether to grant a declaration in the first place. Yeah. Has a discretion as to whether to grant a further declaration. If you come back to the judge and ask the judge to tidy up some aspect of the matter,
in a second action,
that would be permissible in my submission.
So the basis of this third theory are the cases set out in footnote W, a number of which we've looked at. Is that right?
Yes. My own friend has quite correctly said, or his team have said in the case, that the cases referred to in the footnote below the passage about yussive and prohibitive orders, namely Outram and Morwood, and a couple of other cases. My own friend has submitted correctly that those cases do not contain any clear statement that is to the effect of the passage that I have taken you to from Spencer Bauer, and we accept that in our case. But our response is to say that is wholly unsurprising and wholly unilluminating, because no 19th century judge would have been contemplating the collision between the declaratory jurisdiction, which barely existed then, and the doctrine of merger.
No, but what is being said at paragraph 299 about the theory underlying the merger doctrine has been plainly set out in some of the cases to which we were referred this morning.
Absolutely, my Lord, absolutely. My own friend took the court very fairly and thoroughly through the main 19th century cases. Smith, King, and Kendall, and went to the passages on which we rely, which do indeed really mirror the third theoretical justification that we see in paragraph 299. That is correct.
It's quite an interesting explanation of this idea of damning the bond in the footnote W, page 1415, from the Higgins case.
Yes. Yes. Well, there are a lot of metaphors at work in this area, my lady. There are some more being developed in that footnote.
Yes, I don't think we'll be going into bell, book and candle somehow.
No, that reminds me that when in the Court of Appeal, when this aspect of the doctrine of merger was being discussed, Lord Justice Warby referred to what is almost a theological account of the doctrine. when judges spoke of the superior interest that it was created by a judgment. So that then, I think that's all I wish to or need to go to in Spencer Bauer.
Is there no express statement in Spencer Bauer about a declaration?
Yes, there is. I'm very grateful. I was moving on.
You were about to take us to that.
I was. I'm very grateful. I was in danger of overlooking that. I was going to go to, and I do go to page 1417. And at the foot of the page, paragraph 304, states unequivocally as follows, that the author is discussing what is needed to establish former recovery. The following do not satisfy the requirements mentioned and therefore are not deemed, quotes, judgment, close quotes, for the purposes of the plea of former recovery. And then first, a naked judicial declaration of rights and liabilities. And then second, quite closely related, a verdict not followed by judgment. That, I think, would refer to a jury's verdict which did not lead to a sealed or stamped judgment being made by the court. But there we have a clear statement by this textbook, the first edition of this textbook, which has been repeated in every edition since 1924, to that effect, which is obviously consistent with my primary submission on this appeal and with the Court of Appeal's decision in this case.
So on that approach, judgment is given a narrow sense.
Yes, indeed. And that's perhaps I could simply give the court the references to the three 19th century cases which reflect the third theoretical justification. I don't need to go to them because my own friend did so this morning. They are, I think in order of time, Smith at page 957. The court will recognise the relevant passage. King at page 779. And Kendall at 734. And the court will find there, and we'll have seen this morning, looking at those passages, we'll find, reviewing those passages, that the 19th century judges who applied the doctrine, considered and applied the doctrine of merger, unquestionably were contemplating a judgment that conferred an immediate, enforceable remedy or right on the claimant. And we're contemplating, obviously, as I've submitted, an exchange of the, as it were, prior cause of action, substitution for the prior cause of action with the rights conferred by the court's judgment. So that as analysed by Mr. Spencer-Bauer, that is how merger works. And if that analysis is correct, then the Court of Appeal was right in this case, and this appeal must fail. May I then? I think I've said probably as much as, unless I'm invited to go to the cases, I've said as much as I want to say about the way in which the Henderson and Henderson, Johnson and Gore-Wood abuse of process jurisdiction operates to deal satisfactorily with the danger of abusive relitigation, unjust harassment of a party, etc. Unless invited to do so, I don't think it's necessary to go to those cases. May I make one or two, a small number of short submissions about cases to which the court was taken this morning. First, Conquer and Boot. Turning that up at page 548. The short point that, just by way of clarification, that I want to make in relation to this case, which I think reflects a submission made by my learned friend, is this. It concerns the last 3 or 4 lines on page 548, where Mr. Justice Talbot said, "I think, therefore, that the plea of res judicata or judgment recovered is an answer to the whole of this action, and that the defendant is entitled to judgment." The short point that I make, which may be common ground between myself and my learned friend, is this. To a lawyer or a judge at work in 1928, the term "the plea of judgment recovered" would have been used interchangeably with the concept of merger. The two things mean the same, and one gets that from Mr. Spencer-Bauer's book, which obviously was published in 1924. So I would, I think, respectfully submit that when Lord Sumption in the Virgin case treated Conquer and Boot as illustrating a rule that was separate to the doctrine of merger, with respect, his lordship may have been mistaken about that. The two, Conquer and Boot, may be an example of the doctrine of merger being applied.
Well, the case it's applying is Brunsden and Humphrey, so yeah. Indeed. So that is that. It may ultimately not matter very much because the two. We've got enough categories as it is without having 7 or whatever Lord Sumption got up to.
Well, Lord Sumption drew a distinction between merger, which he referred to as a substantive rule of law, and the rule in Conquer and Boot. And
I know, you're trying to slim them down a little.
I'm trying to slim down the analysis a little bit.
I was just trying to work out why he had this extra category. Yeah.
I wouldn't. I couldn't.
You don't have to answer
I either couldn't or wouldn't wish to speculate about that.
I don't think we need to have obiter dicta about obiter dicta.
Indeed. So that's Conquer and Boot. The case the court is, in its consideration of these problems, finds the Serrao case, the 19th century Serrao case, helpful or of interest, or perhaps in any way problematic. It may be helpful just to look in slightly more detail at what Lord Justice Sales, as he was, said about that case in Farrar, which is to be found, I think, at page 608. Yes. Lord Justice Sale's consideration of Serrao and Knoll begins at page 613. Top of the page, paragraph 19, the precise status of Serrao and Knoll is not entirely clear, not discussed or even cited in Virgin Atlantic. And then reading down to the foot of that paragraph, the reasoning of the three judges in Serrao and Knoll is expressed in different ways and is opaque in places, so that extracting its ratio is not straightforward. The facts of the case are then set out in paragraphs 20 and 21. Paragraph 22 at the foot of the page, Lord Justice Sales referred to the opening sentence of the judgment of the Master of the Rolls, which said it is unnecessary now to determine whether there is a fresh cause of action for every day upon which goods are detained, and whether separate actions of detenue can be maintained for each day's detention of them. The learned Lord Justice, as he was, clearly thought that it would have been surprising if the Master of the Rolls had started his judgment in that way, if he was intending to then carry out then to apply the doctrine of merger. And then over the page to 614, 4 lines down. In my view, given the opening of his judgment, the Master of the Rolls was not intending to opine upon the technical position in relation to when a cause of action arises in a case of detention of goods, but was using the phrase one cause of action in a looser sense to refer to what matter overall constituted the subject of the first action. In terms of Lord Sumption's scheme, the Master of the Rolls' reasoning is best explained as an illustration of the fifth principle derived from Henderson and Henderson, and then it's pointed out that Henderson and Henderson itself disappeared from view for about 100 years, came back into, it resurfaced in about 1975, I think. And Lord Justice Sales' analysis then goes on, and I simply place that before the court and submit that analysis of the difficult decision in Serrao is accurate and should be treated as being accurate by this court if this court finds it necessary to consider the Serrao case.
Presumably they're extemporary judgments in Serrao.
I think that's right, Lord, yes.
Court of Appeal.
I think that's right.
But wasn't it key in Farrer that actually the cause of action for mean profits did arise from day to day?
It was, yes. Yes. No one, I think, is suggesting that the decision in Farrer, which seems to make complete sense, is to be criticised. But there is a slight tension between Farrer, where the claimant was allowed to get possession first, then come back for money, and Serrao, when the claimant was not allowed to get the share certificates first and then come back for money. I've made the submission I wish to make about the Indian Grace and the proper construction of the 1982 Act. Then could I just draw the court's attention to one aspect of Lady Justice Arden's decision in Clark. One turns to 529. This is the quite difficult ombudsman case, which may well turn on special facts relating to the ombudsman scheme. The only further point I wanted to make about this case concerns the paragraph at the foot of page 529, paragraph 93. Lady Justice Arden said this: as res judicata may be available, I do not need to consider whether merger is available. Merger could not operate in any case where res judicata was not available. Given that Her Ladyship said that, it would, I respectfully submit, be wrong to treat Clark as giving this court any real assistance in relation to the issues that we are considering concerning merger. Those are the short points that I wanted to make about the cases that have been cited. Can I then sort of step back from the detailed submissions that I've been making about merger and conclude my oral submissions by making some observations about this case and about one wider principle that I respectfully submit this court should have regard to. In terms of this case, obviously this court is not concerned with what might be called the underlying merits that were relevant to the abuse argument that was advanced to the Chief Master and was also advanced to Mr. Justice Burse, where it failed, but which has not been advanced since. However, like any good advocate, my own friend has from time to time in his submissions referred to the fact that apparently we did not explain why we proceeded in the way that we did. I wasn't acting in the initial proceedings, but I'm certainly not going to improperly attempt to give this court an explanation of why we proceeded in the way that we did. But if I may, I will just make these points. 2 points. First, it is striking that in this case, or in the underlying litigation, the first person to apply for declaratory relief was not my client, but Mr. Nasir himself. He brought a claim seeking a declaration that he was entitled to vote on the shares. And we responded a few days later with a cross-application for our own declaration. In our written case, we posed this question, to which I haven't heard an answer. The question was this: what if we had not cross-applied for a declaration, but had simply argued the matter out in response to Mr. Nasir's application for a declaration, and had succeeded and obtained a declaration that determined that the debt was due? I think it's fair to say that on my learned friend's analysis of the position, the obtaining of that declaration in response to Mr. Nasir's application would bring into existence a merger, because we would have obtained a relevant declaratory judgment on the relevant cause of action.
What do you mean? I don't.
You'd have to counterclaim for.
We'd have to counterclaim. We would be constrained to counterclaim immediately for a monetary.
Well, then it's just the same as what has happened, except it's been a separate action.
Indeed. Anyway, he went first. Whether that affects the overall perception of the position, I'm not sure. But he went first. Second,
as long as he had the shares, he would have been, until they'd been forfeited, he would have been entitled to vote on them, wouldn't he?
I think the article said you could not vote if you had not paid for them.
Oh, right. Okay.
That was the problem.
Oh, yes. You could have just defended it. You could have just defended the claim, and his declaration, he wouldn't have gotten any relief.
Yes, perhaps. Perhaps that's not. In any case, I'm not sure that point really goes to the matters this court has to decide. So I will move away from ineffective attempt to go into the merits of the position, and make, if I may, make one final submission of a very different type, but by way of a conclusion. My own friend relies on the two well-established principles, usually expressed in Latin, about it being desirable for there to be an end to litigation and about double vexation. And I've made my submissions about that. I would respectfully submit that there is a further broad principle or policy that this court might wish to have regard to. And I would formulate that further principle in this way. It is I submit that it is, in principle, undesirable, unless there is a compelling justification, it is undesirable for there to be a wholly inflexible procedural rule which, if engaged, leads to the loss of a right of action or something similar. And there is a very powerful pragmatic reason why such a rule is undesirable, and why, if such a rule exists, it should be confined, carefully confined within its limits. And the pragmatic reason why that is so is as follows. Whenever the rules committees or the courts or Parliament create a rule or principle of that nature, there is trouble. Trouble follows. And may I give the court one or two examples? Take first the so-called costs wars of the early part of this century, when the courts, right up to this court, were, a lot of their time was taken up by very complex argument as to the enforceability of CFAs, because the relevant rules provided in absolute terms that the CFAs were unenforceable unless certain requirements were met. The consequence of the rules being provided in those being drafted in those absolute terms was that the stakes were very high. If defendants could take some technical point which would lead to the CFA being unenforceable, they would save themselves huge amounts of money, and consequently satellite litigation raged burdensomely and expensively for some time. Then there was, by way of a further example, a rule in the county court which provided for automatic strikeout if no step was taken in the proceedings, I think within over a period of 12 months or so. That led to very expensive and burdensome satellite litigation over a period of a number of years before that rule was replaced or removed. But again, the same point applies. The stakes were very high because the party, the defendant, who was using, in the words of that 17th century case, the eagle eyes of its lawyers to look for some defect of procedure or some defect in the way in which the case had been conducted, that party stood to gain so much by getting the action struck out that burdensome satellite litigation resulted.
But there is this rule, and you're not challenging it. So all you can really say is it should be, not be.
It should be confined. It should not be expanded. And the proper confining of the rule that one finds in Mr. Spencer Bauer's work and in the Court of Appeal's judgment herein should not be interfered with by this court. So that I have one or two further examples, but the court, for what it's worth, the court has the point that I wish to make about the practical disadvantages that flow from completely inflexible, hard-edged black letter rules of the type that we are discussing in this case. I think allowing for the slight adjustment to the timings, I'm out of time. Unless I can assist further, those are my submissions.
You're not technically out of time because of our late start, but those are your submissions. Thank you very much.
Thank you very much.
Yes.
May it please the Court, just briefly by way of reply, a few observations. The first was the discussion about the meaning of the judgment. Is a declaration, does it count as a judgment for the purposes of this doctrine? Fode is possibly of some assistance in that regard. That's page 980 in the bundle. And in particular at 996. it's bottom 4 lines. If the cause of action was determined to exist, so that's what we're talking about. We're talking about a determination that a cause of action exists, i.e., judgment was given upon it. It is said to be merged in the judgment, or transitum rem judicatum, and then if it's determined not to exist. So the judgment is simply that which determines the existence of the cause of action, and that logic is taken up as well in the Indian Grace, which is at page 922. And at 929 of that judgment, at letter D, there is one observation which I wish to make upon the passage from the judgment of Lord Justice Diplock in Thode, which I've just quoted. This is that the principle of merger, to which Lord Justice Diplock refers as applying where the cause of action was determined to exist in the sense that judgment was given upon it, and then cannot be described as a species of estoppel. And if one thinks about this case, there was a judgment, a reasoned judgment. Mr. Griffiths, Queen's Counsel, as he was, said, I'm giving judgment. That's in bundle 1, pages 223 and 224. And then there was an order that followed that judgment. So in the judgment, the judge determined the cause of action to exist, just as envisaged we've looked at. And then in the order was multifaceted. There were some declarations and there were some coercive orders, because there were orders for costs and the like. And indeed, we won't go to it, but in the Respondent's statement of case, if one picks it up, the section that starts at paragraph 86, they repeatedly refer to this as a declaratory judgment. And in Zamir and Wolf, again, don't need to look at it, page 472, it talks in terms about the declaratory judgment. So that's, we suggest, is clear. That's how everybody has understood this declaration in this case. It counted as a judgment, and we say that that is how it stands.
Well, if the order reflects the judgment, then the two are the same. And but the thing that you take to enforce is the order of the court, and so I mean, I don't see those authorities as making a distinction between the judgment and the order.
It was simply to meet the point that this isn't a judgment that is within the Spencer-Bauer point. This isn't a judgment to which the merger doctrine applies. And we say it is. It is the process, the conclusion of a process in court whereby the cause of action was determined to exist. That is the judgment. It concluded with a reasoned judgment and an order, and we said it's no reason to introduce an uncertainty and lack of clarity there to say, oh, well, it's not a judgment for some purposes, maybe for others. The second point I wish to make by way of reply is that this point that the cause of action includes the remedy, and my learned friend's trade theory, that you have your right under the contract and you trade that in at the end of the case for an order that sum is paid. And it's the trade is the point in time at which the merger occurs. And then, of course, the conclusion of that is, well, therefore, the cause of action is not so much the facts, but it's the specific remedy that's sought. And really, that must then call into question the Indian Grace, because the Indian Grace, at the conclusion of the Indian action, all that was traded there, to use the trade theory, was the claim for £6,000 on the bill of lading for the short delivery of the cargo. There was no trade for the 2.5 million of the damaged cargo. And it introduces this rather curious situation that if you have a vessel, take the Indian Grace, that's lost from a single cause, I accept, and there are two cargoes on board, cargo A and cargo B, opposite ends of the vessel, very little in common about the valuation, for example, of the two cargoes, two very different causes of damage. What we have then is a situation where you cannot bring a claim for damages on cargo A and then later bring a claim for cargo B, one at the front, one at the back. But you can litigate for a declaration on cargo A and then a claim for damages on cargo A. So the two actions that have a closer proximity, both relating to cargo A, they can be duplicated, but the two claims for the cargoes at the opposite ends of the vessel, they can't be. We suggest that that's a very odd result, and it's the sort of result one gets when one adopts an unprincipled approach to these sorts of, I accept, sometimes difficult questions. The case of Clark and Focus Asset Management, Malone for instance, had nothing to do with this case because of that extract at the end where Lady Justice Arden said this is res judicata. But when one looks at the beginning of the judgment, when Lady Justice Arden discusses the doctrines, she's clearly focusing on whether the cause of action is identical. And as we've seen in the cases we looked at this morning, the origins of the doctrine of the Type 1 case, the contradiction cases, and the doctrines of merger are the same. They're all founded on these principles of finality and against double vexation. And the result there was, if you think about it, is very similar to this case, because what the Financial Ombudsman had done has given a declaration. The Financial Ombudsman said, you are liable for 300,000, but I can only award 100,000. So that was an executory order in relation to part of the loss and declaratory in relation to the rest. And some financial services providers honour a declaration of that sort by the Financial Ombudsman. Sometimes they voluntarily just pay. But not in that case. It was contested, held ultimately in the Court of Appeal that there was an absolute bar to the second claim, the top-up claim. We say that if we go down the route that the Court of Appeal have embarked upon, there is a great scope for uncertainty and future dispute. To what extent, for example, may a party start to bifurcate their claims with one or more declarations followed by executory orders? As my learned friend accepted, and I think the point was put by my Lord Legate, in every action on the declaration, there's an implicit statement that you may want to come back for further or alternative relief. And so it might be said, well, there rarely will be an abuse, unless there's some nefarious or malign intent. How does the advisor then advise on the Henderson and Henderson situation? The claimant says, I'd really like to do one declaration for this and another for that, and then maybe we'll seek damages in the future. But will I be safe? The advisor won't know where to start. The advisor will say, well, how long's a piece of string? Your guess is as good as mine. Who knows whether it will be barred or not? Presently, we have a very simple, easily defined rule. The status of judgments of varying natures. My Lady Rose discussing this, the declaration coupled with ancillary relief. At what point do we draw the line? Can we have a multiplicity of actions? And it's never as straightforward as it may appear when we discuss hypothetics in this forum, is it? Because we all know that there will be judgments that straddle the lines. There will be judgments maybe for a declaration in some respects, and maybe some aspect of monetary relief in others. And then there'll be argument about, well, where does that judgment fall? Does the doctrine of merger apply? Doesn't it? Maybe go for the top-up, maybe not. And then it was suggested, well, the defendant met with an Aldi Stores situation, which is, if the Aldi Stores guidance is followed, the claimant says, I'm bringing this action now, a bit like in Clark, but I'm reserving my position in relation to a follow-on action. And Malone, for instance, well, the defendant could force the matter. Well, could they? What does that look like? defendant issues an application for an unless order, that unless a further action is brought, it cannot be brought at all. Where's the jurisdiction for that? All sorts of arguments one could see could flow from that, and how that jurisdiction is to be exercised. And the final piece of uncertainty in all of this is what on earth has become of this very strict maxim that is the origin for all of this law: you can't be vexed twice. Those words predate concepts of merger by 500 years. The earliest case we could find is 1339, where the double vexation maxim is applied. What has become of that? It's become nothing. It's dead letter. Yes, you can. You can sue on the same cause of action more than once. And your only comfort is an uncertain remedy or claim that it's a Henderson abuse. I obviously disagree that the value of declarations will be undermined. It is very simple. The claimant seeking a declaration can very easily preserve their position by including in the claim an unspecific claim for future damage, to take that example. And they simply ensure that when they get their declaration, it's not in the form of the final judgment on the action. They simply reserve their position in relation to those damages. One can now, these days, obtain provisional damages and the like, or interim payments. There's a multiplicity of tools that are available to the court and the claimant to protect their position. So there is no difficulty there in my submission. Spencer Bower, we were taken at some length with Spencer Bower. I didn't deal with the textbooks quite simply because all of the authorities relied upon do not support the propositions that Mr. Spencer Bower, eminent though he was, cite. They are simply his opinion. But when one looks at the cases, King and Hoare, Smith, Kendall, Boutram, when one looks at the cases, they don't support that strong or high a proposition, as indeed the Master found in this case.
Which proposition are you talking about that doesn't apply to declarations?
That statement is unsupported by any footnote when one looks at it. There's no footnote for that. And the other more general statements about the doctrine only applies where there's relief granted, where there's enforceable judgment. The footnotes cite the cases that I looked at this morning.
But do you challenge that there were two justifications and a theory? The theory is vouched by the case law.
No, you see, this is the point. This is why I went back right the way back, because the footnotes in Spencer Bower do not go back as far as we went this morning. So if you go back further in time and look at the root of King and Hoare and the like, it is not founded on concepts of merger. Merger is a metaphysical explanation of what's happened, but the more important principle is that no person shall be sued twice on the same cause of action. And that is why we submit it's not helpful to use and get tied down in these metaphors, whether the cause of action is drowned or extinguished or merged. The fundamental point that underlies all of these is a much more simple rule. You can't be sued twice on the same cause of action. And that's exactly what Lord Justice Titlock says in Thoday. He says that it's the double vexation rule that's at play, and the merger concept is simply the application of that.
So when did the merger take place in this case?
Well, the non-enforceability of the debt, that is another way of saying the merger, when the judgment was perfected, when the order was perfected, granting the declaration. And that meant it was non-actionable. I thought the court might ask me, well, are you saying there's no debt now? And to that I was going to say, well, it's not actionable. It's a debt in the sense that it's a liability that's not been paid, just as if it was statute barred, but it's not actionable. That's very tough, but it's non-actionable for reasons of public policy. The London steamship case isn't of any assistance because that was a case about state immunity, and that was the point that was being taken in relation to those follow-on proceedings. And so we just don't know whether merger would have been taken at a later point in time. One has to remember as well that the Henderson and Henderson is only a procedural rule, whereas the doctrine of merger is is part of the substantive law of English law. So, for example, Henderson has, it's less clear how it applies in arbitration, maybe by way of some sort of implied term or the like. But merger is hard English law, it's substantive law. So when this court rules on what the doctrine of merger is, that applies to all contracts, all jurisdictions that apply English law, automatically. It does not apply necessarily to those locations because they will have their own local procedural rules and the like.
If I understand you correctly, you say that merger, as explained by Spencer and paragraph 299 and the footnote at W, all those cases really should be reviewed now on the basis of the earlier authorities you've referred to. So the cases starting in 1803 should now be reviewed on the basis of what the original metaphysical explanation was.
No, they don't need to be reviewed. The cases all turn on one simple question: is the cause of action the same? If the answer is yes, there's a bar. If the answer is no, there isn't. The doctrine of merger, or the words of merger, are simply used to give some sort of metaphysical explanation of that. But what's really at play, underlying all of that, is this rule against double vexation, which is fundamental, 800 years old. And in answer, finally, the court will be glad to learn, it's an inflexible rule, my learned friend says his last point, and therefore could give rise to hard cases. I don't accept this as a hard case. The claimant, we've never had an explanation as to why they didn't bring the claim in the first action. They didn't call any evidence at the trial. It's all very murky. But even if it was a hard case, and there will be hard cases, the inflexibility of the rule is outweighed by its attractiveness. It is simple. It is certain. It is predictable. The parties seeking advice as to whether to bring one action or two actions can be given a very clear, without doubt, answer.
Well, I'm not sure how you can say that, given some of the distinctions in the cases, like the one about the personal injury and the physical damage. I mean, or when you've got more physical damage, it's quite hard to know, I would have thought, whether merger is going to operate.
Well, the rule is, if it's the same cause of action, you bring it.
I know, but what is the same for these purposes?
Well,
that's the problem, isn't it?
But the effect will be, what will be the effect? The effect of the lawyer giving the advice was, for goodness sake, there's any doubt about the position, bring it all at one time. So it is...
Is it desirable, though, that to say that if you can't bring declaratory relief to establish the rights between the parties without taking the risk that if you don't bring forward all the claims you might want to make for consequential orders, you'll lose those claims.
But
that doesn't seem to be in the public interest.
In this case, this may have been a calculated risk. We have no visibility as to what happened. All we're told is not to assume it was a mistake. Well, if it wasn't a mistake, it was deliberate, which means that it was taken...
My Lord's question was more generalised, as a general proposition, rather than this case. Yes. Is it desirable? And I'd be interested in the answer.
It's desirable always to have more simple and predictable rules. And the rule against double vexation, if it's the same cause of action, is more simple and more predictable than Henderson and Henderson, which is so fact-specific and maybe that's affected by the situation as it finds itself at the point in time that the second action is launched, as, for example, in the Playboy case. So I agree that one can't say this is predictable in the sense that you could put the question into a computer and get the same answer every time, but it's more predictable than Henderson and Henderson. And if one thinks about it, what we have at the moment, we have this very narrow exclusionary law about a cause of action, which is strict, and then a much broader, flexible rule that covers situations where you could and should have brought the claim. And we say that's satisfactory. So there's a laser-sharp exclusionary rule in relation...
The could and should used to be a principle of Henderson against Henderson. The Privy Council, I think it was in Yang Tong case, used that as the test. That is, if it could have been brought, it should have been brought, and therefore it was an abuse.
Which is what...
And that is the same proposition that you're using now today, that if it could have been brought, it should have been brought, and the doctrine of merger knocks it out.
No, because the could have been brought refers not to the same cause of action, but to other claims that are so closely related to the cause of action that was brought, they could have been included in that at that point. So, that's the broad doctrine. So you bring your claims and then you give consideration to any other related claims that could be included at that point. Yeah. But what I'm saying is there is a strong case still for this very narrow, nevertheless strict and certain rule that you can't bring the same cause of action twice. The parties are better able to take advice. Because it's strict, it's more likely the advice will be, we better take the safer option. And in that process, the public policy ends are more adequately served. There will be less multiplicity of suits. There will be a greater tendency for claimants to bring all their claims together. You won't have claimants seeking Declaration A, Declaration B, and then damages. They will all be brought together at the same time. I'm so sorry, I've gone over, but I think I was slightly late. I'm grateful.
Thank you very much.
Short point of detail. In relation to the submission that the 19th century cases deploy what we've referred to as the third theory, but the earlier cases do not. May I just mention the case called Higgins's case at page 656, decided in 1605, which does deploy the theory about an inferior interest being replaced by a superior interest at page 657. And my own friend very properly went to that this morning. But
it was the first case I think he went to.
He did. That was,
day has come full circle.
That was a case decided in 1605.
Yes. I accept that, but when one looks at the judgment, it's built on this principle against double vexation.
Thank you. Well, the court is very grateful to counsel for their submissions. It's not often that we return to the 13th century in our hearings. I would also, on behalf of the court, like to thank those who have sat behind counsel and have assisted counsel in the preparation of the papers and the submissions for this appeal. The court will take time to consider its judgment.